Hi guys, welcome to Labor Law Part 1. My name is Rogers Gedenji, and in this video we are going to be focusing on discrimination at the workplace. Now remember, as a student of labor law, you might have encountered someone who recently lost their job simply because they were pregnant, or they were HIV positive, or they were disabled. Now, these are grounds for discrimination according to the Employment Act of Kenya. And so by the end of this video, you should be in a position to draft a legal opinion advising any person about their employment rights in relation to discrimination. And so, in terms of, again, the course texts for this unit as a new student to the course, you can consider having a look at these textbooks. When it comes to sources of labor law in Kenya, we have the Constitution and the Employment Act of Kenya 2007. Because we are going to be referring to the Act many times in more videos to come, please download it so that you have a copy to follow through. Now, in terms of what to expect, you must know contract law in Kenya as a prerequisite, and this means that as we talk about a valid employment contract, you need to know what are these elements that actually make up a valid employment contract. And so if you haven't had a chance to take contract law, you can please watch my videos on the law of contract in Kenya so that we are able to start off at the same level. Now, focusing on today's topic, which is discrimination at the workplace, the Employment Act provides for the basic standards of employment in Kenya. And also we have its section 5.2 saying that an employer shall promote equal opportunity in employment and strive to eliminate discrimination in any employment policy or practice. And also remembering that once we talk about equal opportunity, when it comes to recruitment, training or promotion, you should be accorded equal treatment. Now, as you can see from this slide, this was section 5.2 and this is section 5.3b. And so also when it comes to matters of promotion, you must be accorded equal opportunity. That aside, focusing on subsection 3, your employer must not discriminate against you directly or indirectly. And these are the grounds upon which he is not allowed to discriminate you against. So should you have been terminated from your job simply because you're pregnant, you're disabled, or you are HIV positive, if you have evidence, you can be able to bring out a case and you'll be compensated. In fact, as we proceed into the discussion of this video, we are going to go through a practical case for a person who was discriminated based on their HIV status and pregnancy, and she was awarded over 6 million in compensation. Again, before we get there, I want us to talk about the exceptions to discriminations. So in terms of exception to discrimination, we have a situation where your employer can be able to discriminate against you and remain within the law. And this is the inherent requirement of the job. So here what we mean that if the job requires certain qualifications that a person doesn't have, that person can't claim to be discriminated against. As you can see from the example on the screen, if a law firm advertises for position of an advocate with experience of at least 10 years, and we have a medical doctor applying for such a job, you may wonder, can a medical doctor sue for discrimination? Of course, here the answer is no. And this is because the inherent requirement of the job requires someone who has been practicing law for the past 10 years, and David comes from a medical background. Now, before we break down what discrimination is and what you need to show in court, or what you need to show as you answer an exam on discrimination, I want us to use a practical case so that we do not speak about discrimination in an abstract way. So in terms of this case, this was a landmark case on discrimination, meaning it's a groundbreaking case. And so this case involved a lady called V.M.K versus Square. Her name has been withheld to protect her identity. So here the story is that V.M.K was employed back in 2000 as a telephone operator on a casual basis, earning 7,000 per month. Remember, she was never given a letter of appointment. She was entitled to no allowances, while her colleagues who worked alongside her enjoyed benefits ranging from their salary, their allowances, and medical cover. Now, as luck would have it, later on the 10th of March 2003, a job advert was posted internally, and she applied for this position of a switchboard operator. V.M.K went ahead to submit her application form and CV. And later on the 22nd of April 2003, the manager wrote to V.M.K informing her that the interview committee had recommended her for appointment to the position of a switchboard operator. Again, the letter included a note that required V.M.K to do a medical examination for purposes of establishing her fitness to take up the position. Again, remember, this medical form did not require V.M.K to conduct an HIV test. So as you can see, in terms of HIV, the form specified specific ailments to which one was to be examined, and so HIV was never included. But when V.M.K went for a medical test, the doctor examined her, and she did not receive any further communication on that matter. Sometime in April, when she was called by the doctor, who informed her that she was HIV positive. Obviously, as you have seen the trajectory of the facts, HIV was never part of the requirement for the job offer, and also there was no need to test her for HIV. The medical form had specified what was going to be examined, but the doctor had gone ahead to examine her for HIV, and he later calls her and informs her that she's HIV positive. Remember, no one can check your status without your consent. And so once this occurred, V.M.K testified before the court that she did not receive any further communication from Quare as regards the appointment. Now, of course, there's so many facts to this case, but just in summary, once the HIV status was, of course, discovered by the doctor, this information was shared among the senior management staff who got to know about it. Now, of course, accordingly, V.M.K was terminated because of this HIV status. Of course, as you can see, that her contract came to an end. Her one-year contract had come to an end at some point. It was renewed for 3 months and another 3 months. But because of the HIV status, while all this was happening and unknown to her, Reverend Professor Jesse had on 31st of August written a letter and kept it in waiting for the claimant, terminating her employment with effect from 21st of August 2009. So you can see that someone has been actually illegally tested for HIV without her consent by a doctor who didn't actually need to test her for HIV because she had not consented and the job had no requirement for her to be tested for HIV. This information is communicated to the senior management staff, and you can see the corresponding frustration V.M.K is facing. Again, even before this happened, some time back she had taken maternity leave and she was not paid for the time she was away on maternity leave. And also, by the fact that she was a woman, the male colleagues who were doing the same work she was doing were earning more benefits compared to what she was actually entitled to. Now, of course, in terms of breaking down this case, V.M.K tested positive for HIV. She was pregnant at some point and no payment for maternity leave was done, and because of her sex, she was not entitled to allowances and she was earning way less compared to her colleagues in the same position. And so, how do you link HIV to discrimination and eventually termination? Remember, there are different grounds upon which you can be discriminated against. These grounds are provided for in the Employment Act as Section 5, Subsection 3, Part A. If you're discriminated according to any of those grounds, then you can be able to bring a case for the Employment and Labor Relations Court. And so in this regard, how did V.M.K link HIV to her discrimination? Remember that you can link pregnancy, you can link HIV, you can link sex, who can link language to your discrimination and eventually termination. But again, for this case focusing on discrimination, how did she actually link HIV to discrimination? And what was the ruling of the court? Of course, before we go into that, remember that when you have such a case, these are the things that you require to demonstrate before a court of law. And this also applies for you as a student when you're answering your exams. This is a test you need to show to the examiner. So in this case, of course, V.M.K established that she belonged to protected class, and this is the class of people who are HIV positive. She also showed that she was qualified for the job, and there was a connection between the decision of the employer to terminate a contract and HIV status. Now, once you prove this, then the burden shifts to the employer to prove otherwise. Remember, to prove these things, you can show documentation showing that you belong to a class of people with HIV. Again, in terms of class, you could be belonging to a class of persons with who are pregnant, class of persons who are disabled. But for this, of course, case you're focusing on HIV. So you prove that you belong to a protected class and that you are qualified for the job. And of course, here V.M.K had been working for this organization for over 10 years. And so again, after proving this, you can see. Just to recap what we've said in a short statement, V.M.K demonstrated that she was being treated differently from others based on her class. Remember, the class here is being HIV positive. An example here is that her colleagues who didn't have HIV had been getting promotions and medical care and other benefits, and she did not get any of those despite them having started in the same position. Now, with this in mind, when it comes again to the court, the burden now has shifted. Remember, V.M.K has proved that she belongs to a protected class. She's qualified to hold a job. She has suffered loss because of belonging to that class. Being HIV negative, rather positive, is a reason why my contract is being terminated. And so, according to Section 5(7) of the Employment Act, the burden now rests on you as the employer to show that discrimination did not take place. So here the court requires you again to articulate in a clear and specific manner the reasons, or rather the grounds as to why you terminated your employee's contract. And in this case, you have to say, look, we terminated V.M.K's contract. This contract was terminated based on 1, 2, 3 grounds, but HIV was never one of them. And then, having done this, of course, the next step here, in terms of the decision of the court, on a balance of probabilities, the court has to use this balance of probabilities test to weigh the evidence that has been presented by the employee. And in this case, looking at the evidence and the trajectory of the things that had happened to V.M.K. Remember, she was never accorded the same treatment like the rest of the employees, from the fact that she earned 7,000. Other male employees earned far much more than her, yet they were doing the same job. She went on maternity leave. She was never paid for that time. She came back, applied for a job, tested for HIV, which was never part of the job requirement, and also she hadn't consented for this HIV test. And once that is discovered, information is communicated to the senior management, and eventually she's terminated. Of course, here the decision was that the termination of her contract was in line with HIV status. And so remember also, even the appointment to the new position never happened simply because she was HIV positive. Being HIV positive cannot be a ground for discrimination at the workplace, as stated under Section 5(3)(a) of the Employment Act. And so, using this test, the court awarded V.M.K over 6 million, and to be specific, 5 million was exemplary damages for discrimination of V.M.K based on her HIV status. Now remember that based on the Section 5(3)(a), all those grounds can go through this same test that you have to prove. Even as a student, when you're answering your questions, remember that the first thing on the side of the employee alleging, you have to show that that person belongs to a protected class, that person is qualified to hold that job, and you can show documentation here. and then that person has suffered a loss as a result of the decision of the employer, which is connected to their HIV status, and then as a result, then they were terminated. Then the burden shifts automatically to the employer to prove why they did what they did, and the court will be able to weigh both sides and come to a conclusion. Now, of course, in regard to this video, this brings us to the end of Labor Law Part 1. Please, again, remember to subscribe to Nairobi Legal. Thank you so much.